matter which went to the Constitution bench in Pramati Education Trust. Now, my lord, I looked into that again, and according to me, my lord, that actually entirely, my lord, supports the proposition that I put forward. My proposition is this, that the only respect in which the Right to Education Act was found to be unconstitutional to aid the minority institutions was that 25% reservation for weaker sections is not permissible under Article 30. So therefore, your lordship said it will not apply to minority institutions. Now, in the course of that, it is true that the last sentence appears to cover the entire act, but there is not a single argument anywhere that any other section of the act is unconstitutional. And in fact, my lord, 23 particularly, there is a wealth of authority going up to 11 judges, which shows that it is constitutional qua minority institutions. Now, there is a new compilation because, as your lordship knows, last time there was no pagination. But, my lord, in the course of making the pagination, my lord, it has been reorganized a little bit, my lord, I believe. So now it is paginated. That is paginated by hand. And that's okay. Because we made some notes. We have made some notes on the margins. Some of the pages will not tell you. Well, this is the perennial problem of compilations. But is it black properly? Pages are there, index is there with the pagination. But this earlier compilation, yes, had these flag marks. It had the flag marks because it was realized that there was no pagination, so the flag marks were put. But we can put flag marks in this also. No difficulty. They are just post-its. No, soft copy doesn't work. How can you know the soft copy? Muller, I'm sorry, Muller. After everything, Muller, we still do not know, Muller, how best to, Muller, make the judgments available to your lordship. Maybe if the book is here, Muller, 2012 6 SCC, page 1 is the matter which went to the Pramati Educational Trust. 3 judges. Look, I have a compilation which has that has it. Very good. That will be very helpful. I've shown it. Have you given them a copy? My son's gonna. Also, this was our volumes 1 and 2. We'll mark it as volume 3. Yes. Please refer to volume 3 whenever you. Yes. Volume 3. I want to be as concise as possible. So therefore, if I may take your lordship, this was the 3 judges bench judgment, Miller. 2:1. 2 of your lordship's judges, Miller, upheld the 2009 Act, and 1 struck it down. Then, Miller, it was referred further up. Now, paragraph 55 onwards is all that I need to place for this purpose, which is at page 42. Okay. Is he giving me SCC on or SCC citation? Gopal, is it an SCC citation or is it SCC online citation? SCC. Page number. No, this is not an SCC citation. What are you looking at? We'll have the SCC citation. Come to para 55. Well, it is the para 55 starting with the inspiring preamble. Yes. This, as your lordship sees, the heading is Validity and Applicability of 2009 Act to Unaided Minority Schools. The inspiring preamble to our constitution. Then, I'm not troubling your lordship with all that. Just come to para 58. The right established by Article 31 is a fundamental right declared in terms absolute, unlike the freedoms guaranteed by Article 19, which are subject to reasonable restrictions. Article 31 is intended to be a real right for the protection of minorities in the matter of setting up institutions of their choice. However, regulations may lawfully be imposed either by legislative or executive action as a condition for receiving grant or recognition. However, such regulation must satisfy the test of reasonableness, and that such regulation should make the educational institution an effective vehicle of education for minority community or persons who resort. Applying the above test in Sidrajbhai, this court held that the rule authorizing reservation of seats and threats of withdrawal of recognition under impugned rule to be valid. So, reservation of seats is not contrary to Article 30. The above well-settled principles have to be seen in the context of 2009 Act enacted to implement Article 21 capital A of the Constitution. At the very outset, the question that arises for determination is what was the intention of Parliament? Is the 2009 Act intended to apply to unaided minority schools? In answer to the above question, it is important to note that in Inamdar, this court held that there shall be no reservations in private unaided colleges, and in that regard, there shall be no difference between minority and non-minority. However, by Constitution 93rd Amendment, Article 15 is amended and 15(5) is inserted. Result is that Inamdar has been overruled on 2 counts, whereas this court in Inamdar has stated that there shall be no reservation in private unaided colleges. The amendment decreed that there shall be reservations. B, whereas this court in Inamdar said that there shall be no difference between unaided minority and non-minority institutions, the amendment decreed that there shall be a difference because minorities are kept out. Then, Article 15 is an enabling provision, and it is for the respective states either to enact the legislation or issue an executive instruction providing for reservation, except in the case of minority education institutions referred to 31. The intention of Parliament is that minority education institutions referred in Article 31 is a separate category of institution which needs protection, and viewed in that light, we are of the view that unaided minority school needs special protection under 30. 30 is not conditional. In a sense, it is absolute, as the Constitution framers thought to be the duty of the government, etc. 62. Reservations of 25% in such unaided minority schools result in changing the character of the school if right to establish and administer such school flows from the right to conserve the language, script or culture, which right is conferred on such unaided minority schools. Thus, 2009 Act, including Section 12(1)(c), violates the right conferred on such unaided minority schools. However, when we come to aided minority school, we have to keep in mind Article 29(2), as stated, its subject. The said article confers right of admission on every citizen, etc.
Just read the last sentence.
Last sentence.
62 of 1 second.
62, yes. 62, is the important paragraph. Shall I place it once more? Reservations of 25% in such unaided minority schools result in changing the character of the school. If right to establish and administer such schools flows from the right to conserve language, script and culture, which right is conferred on such unaided minority schools. The 2009 Act, including Section 12(1)(c), violates the right conferred on such unaided minority.
Entire Act violates.
Entire Act is not deep. I bow down, below. Including it says, but
including.
But below the
USID including.
All right.
Thus, the 2009 Act violates the right.
My difficulty with this approach is, that clearly no other section violates. In fact, to say that 23 violates would go against TMFI Foundation. 11 judges. So, all discussion is relating to the reservation. And then here your lordship finds a line that the 2009 Act, including Section 12(1)(c), violates the right of unaided minority.
So, and big put to you, Mr.
Yes.
That there is an observation in this judgment, maybe based on only 12(1)(c).
Yes.
But the observation is rather wide,
yes.
omnibus.
Yes.
It says the whole act is violative of Article 30.
This would make this entire judgment, both of the two judgments, per-incurium.
You may say that.
No,
See, that may be your privilege, but
no,
it can't be on our side because we'll be bound by 3.
No, I'm not asking your lordships to to ignore the judgment. I'm saying kindly harmonize it with my lord the 11 judges judgment
But the sentence
and come to, and therefore my lord the proposition is this.
This was.
Sides of the coin, my lord, are now clearly delineated, my lord. I leave it there.
Yes.
I just want
Yes.
your lordship now to see
Yes.
that section 23 is clearly constitutional in the light of, my lord, other judgments of much larger benches of this honorable. That's what I want to show. And for that purpose, my lord, to save time, I'll go straight to the last judgment which considers everything from beginning to end,
That is
all judgments. That is the Contai-Rehmania judgment.
anyway. Finish this. We'll turn
No.
to
This is 63.
Yes, sir. This I'm actually done. I'm actually done. 63 is all that is left.
No, this was a 2-1. Ratio was
This is
2-1.
2-1.
How did it reach the 5 judgments?
Because the question was here, it was assumed that Article 21A and Article 15(5) were valid.
Very well.
At least as far as the majority was concerned, there was no question raised as to the validity of 15(5) and 21A. But my lord, when this question was then raised before the court, and when that was raised, it was referred to the Constitution bench. That's why, my lord, in the Constitution bench, your lordship found that the primary issues were
But this judgment says that it will go to a 5 judgment.
no, not this. Not
That was on the constitutional challenge. So there, 21A was being challenged and 15(5)
But after
was being.
this judgment,
Yes.
how did the matter go up to
There is, so if you see Pramati's, that editorial note that I mentioned, that 1-page editorial note gives the entire history about how that happened.
well, in fact, the reference order is also, my lord, reported. Your lordship may just keep it in mind, my lord. I don't have it in the compilation, but the citation is 2012 6 SCC 102. 2012 6 SCC 102. It's a 1-page order. But it has a long editorial note, as my learned friend says. Here, what happened was, my lord, in the very same proceedings, my lord, it appears that the validity of Articles 15(5) and 21,
102?
102. It's a 3-page report, most of it is an editorial note. The order is very short. 1, 2, 3. That the challenge, since the challenge, kindly see, my lord, it is the same
Same quorum.
and it's the same matter, Society for Unaided Private Schools of Rajasthan. Since the challenge raises the question as to the validity of Article 15(5) and 21 capital A of the Constitution of India, we are of the view that the matter needs to be referred to the Constitution bench of 5 judges, Rule Nisa, etc. Now, editorial comment, my lord, says,
No, Mr. Gupta,
yes,
this is September 6, 2010.
yes,
What is the date of this order? What is the date of this order?
previous judgment,
No, this 2012 volume 602.
yes,
What date is this order?
2010.
Huh?
6th September 2010.
6. It appears to be 6th of December 2010, and page 1 is 2012.
your lordship is right, but there is this editorial note, my lord, if your lordship sees.
The editorial note says
Yes,
the 3-judge bench.
yes,
If you just see between classical G and H,
yes,
The order dated 6 September 2012, published above, however, had directed that the writ petitions be placed before the CB for directions.
Yes.
So where is that direction in 2012, volume 6, page 1? Must be having that.
No. Now, my lord,
This is
please just see the next line. Let me place the editorial note. I'm not very sure what happened, my lord, but just see the editor, my lord, has given the entire.
Number 243, ma'am.
After the
Page number 243 of that Pramati, that judgment starts, the opening first paragraph is explained.
Pramati,
243, sir, judgment starts.
give me Pramati. Yes, it's in the compilation. Okay, it's gone from that compilation.
Paragraph?
My index.
Judgment starts minute there. But the text here, I'm referring internal page minute of that. Here in compilation, Pramati judgment starts from page number 242.
No, but it'll take you back here. It just gives a citation of 1261. So it'll bring you back to this. The editorial note actually explains it.
Yes, but the editorial
The
note
note is very comprehensive. Please read that.
editorial note.
Yes,
Yes.
yes, that's very comprehensive. Because it's a mystery to them as well.
it looks like it was decided as an interim order. So kindly see, my lord, this last line of the page 103. After the above order, directing that the matter be placed before a constitution bench on 6/9/2010 was passed. The matter was listed on 7th of January 2011, when the court posted it for hearing on 17/1/2011. Then, my lord, refraining from granting a stay. So that is, my lord, the only thing which is cited is the Hindu report. Refraining from granting a stay, the Supreme Court on Monday agreed to examine the validity of the provisions of RTE, which mandated 25% reservation. The bench of so-and-so did not favor at the moment the idea of referring the matter to a constitution bench. At the moment, we are not going to stay the statutory provision. We are not passing any order. The bench said when Additional Solicitor General urged the court to refrain from passing any orders. So-and-so appearing for the consortium, however, maintained that the organization was not pressing for a stay but suggested that the matter be examined by a constitution bench. Chief Justice said that the court cannot refer the matter to a constitution bench as it was hard-pressed with other work and would only prolong the hearing. He, however, said the three-judge bench would initially examine the matter and only if warranted would refer it to a constitution bench. Earlier, the ASG said that the act had been formulated in tune with constitutional provisions, etc. The main petitioner, the association, and a host of associations questioned the validity. It seems that the above observations of the court were made orally since the order of 17 January in the writ petition read as follows: issue notice on writ petition so-and-so, liberty to complete pleadings, place the matter for directions for fixing of date. After this order was passed, the writ petition was listed and heard on 20 occasions when many more writ petitions were tagged and counsels made submission. The matter was finally heard on 3/8/2011 when it was reserved for judgment, and the judgment was delivered on 12/4/2012 by the same learned bench of 3 judges, reported at 2012-6 SCC page 1. That's the one. There is no order withdrawing or modifying the order dated 6/9/2010 that could be found. The order dated 12/9/2012 is thus decided on the basis that Articles 15 and 21A are valid. In fact, the entire reasoning of the majority is premised on the assumed validity of the articles, see para such and such. Hence, it seems that the question of the validity of Article 15 and 21 remained open, since it has not been decided, though initially the matter has been directed to be placed before the Constitution bench for deciding the same. Then we'll at 145. It doesn't really answer the question. I'm sorry.
I see, Pramati, how does it?
I'm sorry, we have actually found that order. My friend Vishal has just found it. It's 2013, 5 SEC 752. 2013, 5 SEC 752. There is a specific reference order on Pramati.
2013.
5 SEC
Yeah.
752.
After reference.
That's Pramati.
Very odd, very odd. Just look at this. Comes to 768 of volume 1. Volume 2.
Yes.
This is Justice Patanaik's opening remarks.
Yes.
Yes.
This is a reference made by a three-judge bench scored by order dated 6 September 2010.
Yes.
So 6 September 2010, Chief Justice Kapadia's bench refers it to Constitution bench.
Correct.
It is not heard by a Constitution bench.
Third by three.
It is heard by the three-judge bench. And after that, five-judge Constitution bench is constituted.
But yet we find an order separately where Pramati is referred to a constitution bench. That's this one, 2013. This book.
Milord, it may have happened this
Maybe
way.
it's an oversight or a confusion
No,
because even the editor didn't know about it clearly from that order.
But Milord, since this is Pramati Educational, I surmise, Milord, that this writ petition 416 came up later.
But you know, learned senior counsel referred to 102,
Yes.
but did not refer to page 1.
Yes. Strangely, this.
And this is two judges.
Yes, two
Two
judges.
judges.
And they
One of whom dissented.
No, but if you see it, they say refer to the order reported in Society for Unaided.
Yes.
So referring
And
reference order.
No, not the reference order.
Exactly, which is the reference to 5.
No, Gopal.
reference to
No,
5
no, look at the footnote.
2010.
No, the footnote is the final judgment, not
No,
Final judgment.
It's the final judgment of 1, page 1.
Page 1.
Yeah.
So they refer to the reference to 5, and therefore this bench says we should send it to a larger bench. They don't say constitution bench, they say larger bench. For 2, the larger is 3.
No, in view of the order passed by this court,
Yes.
we feel it appropriate. Therefore, three judges found
Correct.
that page 102 said,
Yes.
opening sentence, it has to go before the CB. So then, send the matter to the Chief Justice.
Correct. And he sent it to the constitution.
And by this time, Justice Kapadia had debited office.
Yes, yes. So then it goes to the constitution.
There must have been another order by which three judges referred it to the court.
So administrative side you must have placed.
They might.
Let's see to the follow-up.
Later.
But anyway, I mean, when you're looking at 21A and 15 from the constitution, it's in the fitness of things that a 5-judge bench will look at.
That's true.
Because here it shows that it went to the administrative side. So it went to the chief justice, it didn't go to 3.
But anyway, Milord, both the two judgments have a line which says the entire Act 2009 because of 12.5. But my submission is, Milord, that 23 is clearly, Milord, constitutional in the light of TMFI Foundation documents. Give me a Rahmanian.
Society was,
Okay. So, Milord, now I come to 2020, volume 6 SCC 689.
What is that?
This is Milord Sheikh Mohammed Rafiq versus Managing Committee Kontai Rahmania High Madrasa and others.
The compilation, this volume?
Volume 1, page 77. So, my lord, two things I'll tell your lordship, my lord. You don't have to, my lord, wait through the whole judgment for the time being. The first thing is, my lord, that these batch of matters arose out of, my lord, legislation in the state of West Bengal, where, my lord, a board was set up to appoint teachers to madrasas in Bengal.
Madrasa Service Commission.
Madrasa Service Commission. Now, in the challenge, my lord, what your lordships did was to say that the matter had gone all the way up to 11 judges in TMFI Foundation and then applied thereafter in several judgments. So, judgment is broken up into three parts. The first part are all the judgments prior to TMFI Foundation. That's like Sidraj Bhai, St. Xavier's, all that. That's the first part of the judgment. The second part of the judgment is a consideration of the findings in TMFI Foundation. And then your lordship, lord, deals with each and every judgment which followed TMFI Foundation all the way up to this judgment. So, my lord, this is very helpful because it summarizes ultimately the position as it has obtained up to the date of this judgment. So, my lord, I will not take your lordship's time in going through all the parts of this judgment. It is very instructive because every judgment has been considered. So, three paragraphs first. Because here, my lord, the TMFI Foundation is summarized. Page is 173. 173. We now turn to TMFI Foundation case and consider the principles that it laid down and whether there was reiteration of the principles laid down in the decision of this court in the earlier segment or whether there was any change or shift in the emphasis. Then para 50, which is the beginning of the exercise, 5 incidents were stated to comprise the right to establish and administer, and 3 of them were stated to be right to admit students, right to appoint staff, right to take disciplinary action. The discussion in the leading judgment was under various headings, and the important one being to what extent can the rights of aided private minority institutions to administer be regulated. Then earlier judgments were considered. And then C43, my lord. The decision in TMFI Foundation rendered by 11 judges of this court thus put the matter beyond any doubt and clarified that the right under Article 31 is not absolute or above the law, and that conditions concerning the welfare of the students and teachers must apply in order to provide proper academic atmosphere so long as the conditions did not interfere with the right to administer or manage. What was accepted as correct approach was the test laid down by Khanna, Justice, in Ahmedabad St. Xavier's College case, that a balance be kept between two objectives, one to ensure the standard of excellence of the institution and the other preserving the right of minorities to establish and administer. The essence of Article 30 was also stated to ensure equal treatment between the majority and minority institutions, and that rules and regulations which would apply equally to the majority institutions as well as minority institutions. But equality, not that there was going to be some special dispensation for the minority institutions in the matter, my lord, of appointment of teachers. Then, my lord, Malankara is referred to, Sindhi education is referred to, Chandana Das is referred to. These are all post TMFI